In episode 3, we have the Hays County District Attorney, Wes Mao. We explore the process of going through a specialty court, the difference between sanity and competency, and how a lack of resources negatively impacts those with mental illness. After we shared our introductions, we got right down to business. As a district attorney, what is it that you do? What does your day-to-day look like?
As the criminal DA, my office handles all the criminal prosecution in Hays County, so misdemeanors and felonies. Class C work like traffic tickets and things like that when they're filed with the county authorities. My office also has some civil jurisdiction, mostly things that are related to criminal cases like bond forfeitures, asset forfeitures, things of that nature. But then we also represent the Department of Protective Services in child protective service cases. And in terms of mental health specifically, that obviously intersects with the criminal law quite a bit, so we have to deal with it there. But my office also handles involuntary mental commitments on individuals.
Okay. So what do you think is your favorite part about the work that you do?
As an attorney, I think that the best thing about being a prosecutor is the job of a prosecutor is always to see that justice is done. So I don't have a client who may be asking us to do something that we don't agree with. If you're a defense attorney and your client says, I want to go to trial, even though you know your client is guilty and he'd be better off entering a plea, you have to do what your client wants. If you are a civil lawyer and your client wants to sue somebody, you may or may not agree that your client is correct in doing that, but you kind of have to do it because that's the job of an attorney, is to represent your client. And there's nothing wrong with that. I don't want to give you the impression that prosecutors are somehow better than other attorneys in that regard. But in terms of being able to make decisions that are based solely on our view of what justice is in the case, that is, I think, just a much more comfortable position for at least somebody like me, where I can always pretty much do what my conscience requires.
Okay. That sounds great. So what frustrates you about your work, or what might be the most challenging thing?
There's obviously a lot of built-in challenges for prosecutors. We have the burden of proof. Clients, defendants are innocent until proven guilty. So even though we may feel like a defendant is clearly guilty, we still have to go to court. We can't just simply, wave our hands and have whatever we feel like justice is. We also, of course, have a lot of support. The police departments and sheriff's offices, all those law enforcement agencies do support the work that we're doing. They bring us the cases and investigate the cases. So there are frustrations with it, just like there are in any other field, things that you wish you could do that you can't. But one of the most frustrating things I find generally is the perception of the public of law enforcement and prosecutors and people that are involved in the law enforcement community is often driven by individual actors who are doing bad things or doing unethical things in isolated instances. And that tends to reflect on all of us, which, it's unfair, but that's human nature.
Have you ever noticed a link between mental illness and incarceration, or correlation between the two?
In the criminal context, quite frequent that people who have mental illness do commit acts that would be crime. Those situations can, first off, they create the situation where this person just gets arrested and goes to jail, and that starts a whole ball rolling in the criminal justice system. That person, if they were mentally ill at the time of the crime, that could lead to issues relating to their sanity, and proving whether or not they were sane or insane at the time the crime was committed, make a big difference as to whether that person is even guilty or not. And there are people who are in jail who simply developed or who had mental illness when they were incarcerated. And depending on the type of mental illness and the severity of it, they may not really understand what's going on. Competency and sanity are two very different concepts. Sanity can potentially be a defense and may be a potential issue in whether the person is to be found guilty. Competency just kind of stops the whole case in its tracks until that person's competency can be restored. That's a big issue in criminal justice right now, because the facilities, the doctors, the hospitals, the places that you can send a person to have their competency restored, treated to the point where now they do understand what's going on. They can talk to their lawyer coherently about their case. That creates significant delays in those cases, just because that process has to take place, but just the delays in getting the person into that process, getting them a bed in a hospital or a place where they can go to get their competency restored. People sometimes end up sitting in jail for most of the time that they could be sentenced to. I mean, if you have a case where you have a 1-year maximum sentence that can be assessed against this person, it take you a year to get them a bed in a mental health facility so their competency can be restored. Well, by the time their competency is restored, now we can try them. They've already served the entire amount of time that we could ask for them to be sentenced to. We're just stymied. You can't do anything until the defendant is capable of going to trial. You can't even ask him to plead guilty. Even if he knows he's guilty, his lawyer knows he's guilty, bargain all worked out. We can't do anything until the defendant is competent to make that decision on his own.
So with competency, with the example that you gave, if they were to sit in jail for a year and wait, and after being tried, would they then serve that time?
No, they would end up getting credit for that time that they had spent.
Okay.
But that's the thing. At that point, the system is operating just to create the record that the person committed the crime. You may want that conviction on their record for good reasons, but we don't want the person to sit in jail for a year. You're going through all of these motions and trying these cases to get nothing more than a signature on a piece of paper because the person's already served the sentence. So that's frustrating and not really, I think, what anybody wants. Don't have the availability of the resources to move those cases more quickly.
Do now explain how sanity determines whether a person will be held responsible for criminal actions, whereas competency determines whether a person will be able to appear at trial and understand the proceedings. Competency can be restored at mental health facilities, but they're currently overpopulated. So instead, those with mental illness wait in jail, sometimes for almost a year, until they can get a bed, to restore competency, and then to proceed in court with charges brought against them. So I had to ask, how is the criminal justice system treating people while they wait?
What generally happens is, a defendant gets arrested, they get charged with a crime. When they go into jail, they do an assessment to see whether they've got any kind of mental problems. And those mental health issues may not even relate to, competency or sanity. It just may be the person's depressed or they may be suicidal. And there are things the jail needs to be concerned about. But once we get into the courtroom and the person has their attorney is generally the one who's going to raise this issue. As they talk to the defendant and try to find out what their defense is going to be and get the defendant's side of the story. If they realize this defendant doesn't know what's going on, client who doesn't communicate with me effectively, bring that up with the judge. The judge determines that competency is an issue. They will first assign a doctor to evaluate the defendant to see. Once that's confirmed, then depending on the crime the defendant is charged with, they will either be assessed and treated at a secure mental health facility, or they may be treated at a non-secure facility, basically a lesser degree of facility. I'll just give you an example. Right now, we have 13 people that are sitting in jail waiting on those options to take place. Only one of them is waiting on a list for the maximum security unit. But then the rest of them are waiting for other kinds of treatment. For example, at the Austin State Hospital. Right now, last we were told the average waiting list for those individuals is 213 days for males and 205 days for females. You can see if 213 days, that's 7 months, that we know we can't do anything with this case while we just wait for this person's competency to be restored. The misdemeanor case, that may be longer than we even are looking to incarcerate them for. It's a felony case, that may not be the situation, but even if it's in the felony situation where we may be looking at putting a person in prison for a long time, and so the 213 days isn't that big a concern in that regard, it's 213 days that we're not moving the case forward.
More resources are needed. Without competency, it's a waiting game. My goal is to understand the efficacy of mental health courts and the benefits they can provide. What role could specialty courts play in this situation?
Specialty courts generally, and there are a variety of them. There are drug specialty courts, there's veterans courts, and then there's mental health courts. What they're generally designed to do is to provide a more intensive interaction with a defendant who has a problem that is causing them to interact with the criminal justice system. And the hope is that by having this more intensive interaction with the court, they will get some additional help or some additional attention that will hopefully prevent them from committing further crime. It is a much more intense process than, for example, a regular probation would be. Come back to court a number of times. They have to meet with individuals that are involved in the system, social workers, psychiatrists, and try to get a handle on those issues, which often involve, drug abuse, alcohol abuse. As that program progresses, if they successfully complete it, then the case ends up getting dismissed. They can have the case expunged. And the idea there is that this is a person whose criminal behavior is not really their fault. And so we work to try to just deal with the core issue It is not easy. It is intense. It's sort of a separate sort of consequence for those crimes than what we normally think of in the criminal justice system. And none of these courts are necessarily exclusive of other kinds of criminal justice consequences. So, for example, you can be in a drug court and still serve some jail time, or you could be in a mental health court and still potentially have to be on probation. But the idea would be it would provide a centralized court where the judge, the prosecutor, the defense attorney, the resources that are brought in through various grants are all focused on mental health and cases where mental health is the core problem, whether the person needs to be held in an inpatient facility or treated outpatient or whatever that would be determined during that process. They would be constantly monitored, constantly having to come back to court for progress reports. And assuming that things were going as we hope they will, get a handle on that situation, the person gets treated with whatever it is that they need. And then we hopefully don't have to worry about that person committing future crimes.
So, knowing that these specialty courts have benefits, why do you think there aren't more of them?
The resources that you need to have an effective specialty court are not insignificant, and that costs money. So, for example, we can't have somebody meeting with a psychiatrist once a week unless somebody's paying the psychiatrist. Can't have prosecutors showing up 10, 15, 20 times on a case where they would normally only show up 4 or 5 times on a case without, using those man hours and having somebody that's going to be paying that prosecutor to do that. Individuals that are involved in those courts have to be trained, various types of things that they need to know in order to be able to effectively manage those courts, which is why most of the time when those courts are in place, they are created through grant, a state or a federal grant, or both. A variety of grants can be sought for those things. The mental health court, for example, specifically in counties in Texas where the population has exceeded 200,000, they're required to have a mental health court, but they're not required to have one unless they can get grants to fund it. These things are not something you can simply put on a county to do. That's, I think, probably why you don't see it more frequently is smaller counties, and most counties in Texas are smaller counties. Mental health courts with much prevalence because they're just expensive to operate, and unless you've got a state hospital in your county or access to a lot of those resources nearby, probably not going to see mental health courts that much.
Okay. I answered some of my other questions in there, so that was really great. But knowing that they could be beneficial, as we kind of stated before, and that grants are going to be a big factor in pushing them forward. If grants are not available or counties aren't able to get that funding, what would be an alternative? Since there is a problem that exists,
any alternative that you talk about is always going to cost. There's certainly an argument to be made that if your option is incarcerating the person or treating the person's mental illness, that it may be less expensive to treat the mental illness. For example, here in Hays County, if we have to transport a person to a mental health facility, we're generally taking them to Kerrville, which is a 5-hour round trip. So it's not just something that we can do on the spur of the moment. There are some other alternatives that can be used. There are some pilot programs that the Health and Human Services Department is working on to do jail-based competency restoration, where a psychologist, psychiatrist will come to the jail and try to treat the person there. That has some potential benefits to it in that you don't have to transport the person to a state hospital. But there are also some studies that have shown, and some doctors who object to doing that kind of work in a jail facility. The facility is not really designed for promoting mental health. It's not the best way to do it, although that's obviously a cheaper option and potentially a more available option for a lot of counties than transporting the person to a state hospital. As I mentioned, those are pilot programs. That's not available to everybody.
in dealing with specialty courts and mental health court, I know that you mentioned that people have to apply for them. So who has access to them and who makes those decisions about who will be able to participate in them or not?
Yeah, most of the time, the way those specialty courts work, there is a committee aspect to it, where the idea behind a specialty court is we're not really fighting about whether this person committed a crime the way we do in regular court. What these specialty courts are designed to do is to make collaborative. So, for example, the way our Veterans Court works, if a veteran goes to jail, there's a big sign at the front of the jail that says, if you're a veteran, you can apply for Veterans Court. Any defense attorney who works in Hays County will know if the defendant is a veteran, and that's on all of their intake paperwork. And so this committee will get together, make a determination that this person is or is not the type of person that Veterans Court is designed for. And if they are, then they admit them to the program.
Okay. And then a clarification question. How would the intersection of competency and mental health court, how would that intersect, which would take precedent?
Well, the mental health courts can be designed in a variety of different ways. In mental health court, there's going to be a lot of situations where, mental illness may be a problem for this person. It doesn't necessarily excuse their conduct. Maybe I've got clinical depression, but that doesn't necessarily mean that I didn't know what I was doing when I committed the crime, and I should still potentially have a consequence there for that crime. So the mental health resources would really be focused on getting that person the assistance they need when that person is conceding that they're guilty of the crime. If they want to say, I'm not guilty and I shouldn't be punished, that's what the criminal justice system is really designed to deal with. Have those issues hashed out in a regular court. The health court will be, like I say, this collaborative effort. Everybody agrees essentially on what should be done here. We just move forwards with trying to make sure that those resources are applied in the best way they can.
Once again, I just wanted to thank you for your time and for allowing me to have this interview with you this morning.
Good luck with your thesis.
Thank you so much.